Everybody, and welcome to the webinar, Practical Steps in Getting a GDPR Program Off the Ground. I suppose for many of you, the first question that comes to mind is, it's a little late to be talking about this, isn't it? And the answer to that is, it depends. It depends on your circumstances. If you're one of those organizations that has been processing personal data in the EU since before May of 2018, then yes, it's a little late for you guys to be getting started. But if you've been fortunate enough to not have been breached, then, thank your lucky stars and get started, because if you do get breached and you haven't done a thing about addressing GDPR regulations, there will be serious ramifications, which I will go into later in this presentation. Alternatively, you might be a company that's thinking of doing business in the EU, and that would entail handling personal data of people in the EU, in which case it's good for you to start thinking about this now. So without further ado, on with the show. First, a little bit about myself. I'm Joe Donahue, that's me, a highly doctored picture. I was a Y2K compliance manager many, many years ago at the New York Times. And then I went on and was a compliance manager for Great Global Group. And now I'm a GRC consultant for ZeroDayLab, an organization that has started out as an ethical hacking organization. And they got so good at poking holes in people's systems that and environments that the clients started asking them to design controls to protect against people like our ethical hackers, and actually really protect against the bad guys, because our ethical hackers are ethical, and they do a lot of great work, and they have a lot of grateful clients. So Google us sometime or come to our website, read some of our success stories. But now on with the show. So EU GDPR, so you want to enter the European market. That's great. There's lots of opportunity. It's a prosperous region of the world, and if things keep going, it'll stay prosperous and keep raking in the money. It's a very modern part of the world. If you've never had the pleasure of going over there, which I've been lucky, but I think we all know this, that they're very connected with ubiquitous mobile devices. They're avid users of social media as well, a lot like us. The world's getting smaller, and you probably interact with many people in your social circles who are over on the other side of the pond. If I'm talking to people from the US, of course, there's folks in Europe who already know these things about their home. And, analytics around personal data to target consumers or build businesses around. These are really good opportunities for analytics folks. But it's also, even if you're going to go into business and you have no intention of doing analytics of personal data, if you're going to have staff in the EU, then you're subject to GDPR, because you're going to be handling that staff's personal data, and you're responsible for that as well. So the thing about Europeans is they don't like to share like the folks in the US. And when I say share, they don't like to share their information. They ask questions like, what information are you taking from me? Americans don't seem to be as concerned about that sort of stuff. Who are you sharing it with? They want to know these things. A lot of the folks in the US are, we click things, we take pictures of our meals, we show everybody our vacation pictures and our children. Europeans are a little bit more circumspect about that. What are you planning to use this data for? That's another question that comes up a lot. And how long are you planning to keep it? Lots of questions. And these are the sorts of questions that GDPR was intended to address. And finally, how can I get it back or have it deleted? How can I have my data deleted? How can I get it back? These are, in many respects, mind-boggling questions for people in the US who just take it for granted that you will just give them your data and then you can just go on your merry way, and thanks for the information. We'll be sharing it with whomever's going to pay us top dollar, or we'll keep it for ourselves. That Europeans do not go in for that sort of thing, and I think it's something we can learn from. So we US folks, of course. So without further ado, we're going to go on. So the thing about GDPR and managing personal data is you just do not want to get this wrong. Fines are steep. They can be as high as 20 million euro, or 4% of global revenue. That should be a million there, but you get the point. Massive reputational damage as well. If you have a data breach of significance, this can be serious reputational damage. People might not want to do business with you in the EU if you are breached, and it will become part of the public record if that happens. You're not just going to get a fine. It's going to be out there. It's going to be part of public information, so people know that they've been breached and that organizations are holding them accountable. So perhaps you're saying, you know, I'm not really worried about GDPR because we're already protecting PII, so this ought to be easy. Yeah, there's PII. And what is PII? It's information that can be used to distinguish or trace an individual's identity. That's the definition by NIST, National Institute for Standards and Technology. But personal data is a broader category. There's a long definition. I'll let that sink in for a second, but it's a much larger thing than merely personal identifiable information. So I'll elaborate upon that in the next slide. So right down here, we got the smaller circle of PII. That's personally identifiable information, and that's all things like name, home address, social security number, passport number, biometric data. That you know, if this is your blood type and it's associated with you, well, okay, that's personally identifiable information. Maybe that's not a great example, but now you know what? Retinal scan. That's a better one. Or fingerprints, something like that. These are things that can identify you. Blood type, not so much. But now we go to GDPR's idea of personal data. That's a much broader category. All of that PII falls into it, but it also includes things like social organization membership, political affiliation, online activity, what websites you go to, what things you buy regularly, what newsletters you subscribe to, sexual orientation. All of those things are, you know, things that people might not care that you know about, or they do care about that you know about. There's some political affiliations that you might think, you know what, maybe people wouldn't be too cool with that, or maybe I don't want people to know that I'm a member of the Elks. I am a member of the Elks, and I want everyone to know that. But I'll move on. So here we are at this crossroads of entering GDPR scope work. So there's a lot of questions: who, what, when, why, where, how. We'll get into that. So under GDPR, there are a lot of requirements. I'll only be discussing a few. These are data protection impact assessments. You need to do those to get the ball rolling. Managing data subject rights. Data subjects, what's that? Well, the data subjects are the people whose data you're gathering. Simple enough. So that those are the data subjects. You are the person. I want your data. Third-party management's another area that I'll go into, because you know, you can take data of people and then maybe you have subcontractors, those analytics experts out there who really do wonders with taking people's information and really targeting marketing towards them, or making insurance programs for them, or finding you know, a perfect vacation or a home for them to live in. Those people those analytics folks, you hand that off to them. Well, guess what? If they have bad practices, if those suppliers of yours, the vendors that you contracted with, and they're breached, you will be held accountable for it as well, for that breach as well, because you need to ensure that you're making sure that they're doing what they need to do to protect the personal data you've been entrusted with. More on that later, of course. And then security by design is also a requirement of GDPR. And what that entails is basically showing that you're doing your utmost to employ best practices to protect personal data. And also, we'll be talking about the data protection officer. You know, this is a heavy position, a lot of weight on this person's shoulders, but there's a good side you'll hear about later for being a data protection officer. It has to do with job security. So let's talk about the approach to compliance first and foremost, and this applies to anything. It's not confined to GDPR, but what I'm going to describe here is when you have compliance, first you want to, and risk management, what you want to do is you want to articulate the business objectives. So, you know, if you're in a pharmaceutical business, you want to sell products that help get people better. But you also want to identify applicable regulatory and contractual requirements. So, okay, great. You want to go into the pharmaceutical business, that's great, but that's a heavily regulated industry, and there's serious contractual requirements that you'll encounter along the way as well. So what you need to do is you want to establish policies that align with business objectives to meet contractual and regulatory requirements. So what that means is, look, you want to have policies that say, okay, look, we want to be able to sell our products to people, but we understand that there are rules that are governing us. So we need to have practices in place that ensure that, well, we adhere to these regulations, but then we also don't want to hamstring, we don't want to hamper the business too much with this. So we want to be able to design controls that will meet those requirements, but also give our organization the leeway to get their work done. And you also want to inform staff of their responsibilities in meeting these requirements. It's awareness training. And then you want to build repeatable processes intended to meet the regulatory requirements. You know, you don't want to do things in an ad hoc way. You want to have a consistent manner of carrying out your day-to-day activities that align with your policies. And you want to document execution and fulfillment of processes, because if you're in a regulated industry or if you're subject to stringent contractual requirements, you're going to be reviewed for that. You might get audited. People want to make sure that the things that you've committed to are getting done in the way in which you said they would. So that's what what I'm talking about there when I say we want to audit the controls in place for efficacy. You want to make sure that, hey, these controls, they're in place, they're doing it, but are they also effective? Are they really accomplishing the goals that the controls are set out for? Because I think a lot of the times organizations, they understand that they have to put controls in place, and they say, hey, we got to do, we got to make sure that antivirus is on all machines, and that's right, you do. But, you know, is it effective? Do you have antivirus on there? Great. Did you set it to be updated on a regular basis, or did you put it on once and then you notice, you look at the antivirus console and you say, hey, this thing hasn't been updated in months. That's not a very effective control. So that's one of the other reasons you audit, not to see, just to see that you've done what you say you do, but also that you have something that actually amounts to something useful. So this is how things break down with compliance. You have policies, they say what we do, what we don't do, very simple. You have procedures, how we do it. You know, you need the procedures. So policies, we put antivirus on all machines. Procedures, we make sure those, the antivirus definitions are updated on a regular basis. And then you gather evidence to show that you're doing it. So how we prove we do it. So what you should know is you won't be audited by any EU authority. Great, we can end this. We can just go away and thank our lucky stars that we won't be audited by any EU authority. But if you're breached, they will investigate to determine if the breach was the result of your negligence. So that's what I'm going back to. If you haven't done anything yet and you get breached tomorrow, there will be serious repercussions. So there's a lot involved in getting your GDPR program off the ground. And one of the biggest pieces of advice I give all my clients is you gotta get buy-in, distribute the responsibility. There's this great quote, many hands make light work. I've tried to see who, I thought it was an old African, I want to say Yoruba saying, but then other people have claimed this. So it's a great saying, so no wonder everybody wants to claim it, but I'm going to give it to the Yoruba because that was the first one I heard, but don't hold me to it. So get buy-in and distribute the responsibility. The important thing is this is not a solo job. It's not even a solo department-wide job. All areas of the business have a role, and executive sponsorship is a must. You cannot get a program like this off the ground without having the senior leadership say this has to get done, and you people will be held accountable. Everyone will be held accountable. So the message for senior management in order to get them to sponsor this is the fines alone can do serious damage to our bottom line. Negative publicity of a breach can take another substantial bite out of profits now and over time. Because, you know, if you get breached now, you're going to hear about it in the news cycle, and you may get great practices in place so that'll never happen again, but people will remember when you got breached. You know, the reputation is the hardest thing to build, and it's the easiest thing to lose. And if you lose your reputation and you say, boy, entrust us with your personal data, no, I don't think so. I think I'm going to go to your competitor. So with that being said, you can tell your senior management strong security around personal data can be a differentiator. If your website shows that you're doing all the things that you need to do, people are going to say that's a trusted party. That's somebody I can do business with. That's somebody who can grow with me in the next 10 years when, you know, GDPR is not going to be the only game in town. There's strict regulations coming at us from all over, whether it's the cybersecurity laws that are already in place in places like New York and California and Massachusetts, and other entities will be making similar demands. So how do you get accountability? How do you distribute responsibility? Well, what you do is you build a RACI matrix. Sounds fun, huh? What is a RACI matrix? Well, RACI is an acronym for responsible. You identify those who do the work to complete a task or process in the responsible column. Then you decide, then you record accountable. There's the A in RACI. Those who are answerable for success or failure of a task or process, the bosses of the people who are responsible. Consultative, those whose opinions are sought in carrying out tasks or processes, e.g. subject matter experts, or you know, you have marketing people who, you know, who need to be in the loop on what we're doing, and they can offer you guidance on, you know, what the targets of the data are, the data that they need to have, etc., and their own responsibilities. We'll go into that later. And informed, those who are kept up to date on progress. So that could be senior leadership. So that's your RACI matrix. And let's just start off first with the data protection impact assessment. This is one of those foundational exercises in building your program. So what is a data protection impact assessment? We'll call it DPIA. It's not much easier to say than data protection impact assessment, but it's easier to read. It's a tool that helps organizations identify the most effective way to comply with their data protection obligations and meet individuals' expectations of privacy. That's what a DPIA is. What information should a DPIA capture? Well, it should capture a description of the processing, operations, and the purposes, what's being done and why. It should have an assessment of the necessity and proportionality of the processing in relation to the purpose. So, perfect example would be, somebody wants to sell you ice cream over the internet. They have a great idea, and it's going to get to your house, and it won't be melted. Good luck. But they need to know your address, your name, that sort of stuff. But okay, so I'm signing up for that, but do you really need to know my date of birth? I don't think so. Then don't gather it. There's no need for that. And if they want to go further, like who's your favorite rock star? Who are you dating? Well, why are you asking all of these questions? Are you really selling me ice cream, or am I the product? An assessment of the risks to individuals. So as you gather data, the data that you gather, you need to assess the risk to individuals. So maybe, sure, I'll let you know my favorite rock star, no big deal. But I'm not going to let you know who my wife is. I'm not going to let you know my date of birth. So if you do have that, there's a risk to me personally, because that's personal information that can do me harm, perhaps. If my wife finds out I'm getting ice cream over the internet, she'll kill me. Risk reduction measures. So you also need to capture risk reduction measures. Okay, so there are risks to the individuals. What can we do to mitigate those risks, to lessen the impact should that data be breached? So, when is it necessary to conduct a DPIA? Well, per Article 35 of GDPR, where a type of processing is likely to present a high risk to the rights and freedoms of natural persons, you need to, it needs to be done. When conducting an extensive evaluation of a person to make major decisions about them, such as loan approval, or whether or not you're going to let them into their university or their social organization like the Elks. Processing of special categories of personal data referred to in Article 9, such as ethnicity, political opinions, or criminal offenses. If you're processing that sort of personal data, well, you're going to need to do a DPIA. Why are you looking into my criminal past? Unless you're just writing my biography. But data protection impact assessment. What are the benefits of a DPIA? Well, one is they proactively identify project activities and prepare for implementation in a timely manner, which is a good thing. You can plan things out. You're not just going to be jumping right in and saying, okay, we're going to gather all this information. Well, how are you going to do it? What are you going to do with that data? And how are you going to protect it? You got to start thinking about these before you start pulling this stuff in. And do we need it, most importantly? A DPIA also clearly defines roles and responsibilities for data controllers and data processors. It establishes accountability. So that's rather important. It reinforces the principle of privacy by design, because this is the designing document, and you're sitting down and you're making sure that, we are serious about protecting the privacy of our data subjects. And it also helps reduce privacy risks through implementation of appropriate controls, because a DPIA, remember, looks into mitigating the risk, reducing the risk. So they're being proactive and making sure that before we even consider gathering this, we need to understand how we can protect it. So that's a really good thing. So let's quickly go through 10 steps for scoping a DPIA. 1, you want to perform a pre-assessment with criteria to determine the need to conduct a DPIA. So let's go back to that earlier slide where I said under what circumstances you need to conduct a DPIA. Refer to that. See if you need to do it. I don't want you to do work you don't need to do. But once you have determined you need to do a DPIA, you want to consult stakeholders and identify information owners to determine data to be gathered. And you know, a lot of times people will say, well, isn't that IT's job? And well, you know, IT, you know, they create the environment for you, but you decide, the business decides what goes into the environment. And then you need to initiate a data classification exercise. You know, is it high risk? Is it low risk? Is it confidential? Is it proprietary? All sorts of, you can come up with these classifications internally and define how you see that data. Then you identify relevant risks using interviewing, leveraging awareness training to unearth privacy issues. So you know, you talk to people on the business side who say, who you want to say, why are we gathering this? And then you talk to your legal folks and say, what's the risk in us gathering this particular information? And then as you get better understanding, what you want to do is you want to start getting the word out to the larger community within your organization, that all phases of the organization, talking about the issues of gathering personal data so that they understand that they're custodians of that data as well, and that they have a standard of care and they need to understand their role in it. So you want to perform a data protection risk assessment. So you want to look at that data and see what the risks are and how they can be mitigated. You want to identify where data resides, at rest as well as in transit. You know, and it's also data is also physical data, you know, printed out documents, that's also important, and that's also in scope for GDPR. We're not just talking about digital, we're talking about information that can impact an individual. So 10 steps for processing the scoping of data. We're on step 7. Recommend a set of controls appropriate to the risk. So you've done the risk assessment. Well, let's put in some controls to make sure that you know, we can protect this. Write a formal DPIA report with ownership clearly assigned. Going back to that RACI matrix, you probably want to have RACI in that DPIA so that we all know who does what with each of the items of data listed. You want to create an org chart that lays out roles, responsibilities, and accountabilities. You'll reference the RACI matrix that we discussed. And you want to review and maintain. This is a living document. And the data that you gather today, maybe that's not data you're going to gather tomorrow because you've found out that it has no relevance to what you're currently doing. And that only comes from doing a review of your DPIA and saying, yeah, I guess we really don't need to know that guy's favorite rock star in order to deliver him ice cream over the internet. So we're not going to include that any longer in our data gathering. So here's my tip for you folks, free of charge. ISACA, a wonderful organization, has an excellent GDPR specific DPI template. So if you've never done a DPIA, here's a wonderful resource. Go check it out. Of course, you know, you could get on your friend, go talk to your friend Google, and you can go find those. But the folks at ISACA really know what they're doing in this regard. They've been preparing for this for years. They kind of live for this. I'm a member of the ISACA community, and this is sort of our bag. So, managing data subject rights. Now, This is really a big nut to crack. One of the things you need to do is obtain a data subject's informed consent. And informed to pass on their data. It's not enough to just say, hey, can we have this? They need to have those questions answered. Remember those questions we were talking about? What do you want to do with my data? Who are you going to share it with? All that sort of stuff. All of that sort of stuff needs to be explained to the data subject in order for them to hand over their data in a legal manner to you. So the informed consent requires explaining to the data subject the purpose for processing their data, how long this data will be held, what other entities will have access to this data. You know, what suppliers are you going with? If you're going with suppliers, you're going to give it off to some analytics company to crunch those numbers and tell them exactly what they need. You got to tell them the risks around their data, the rules and safeguards, including how to exercise their rights. And we'll go into those rights a little bit later. Oh, and one more thing. This information must be presented in a manner that's easy to understand using clear and plain language. Oh, good Lord, that's a lot. And actually, it's not as onerous as you think, but this might be something that you want to talk to folks in your marketing department. If you're a company that's doing data analytics, they should be able to articulate the benefits to the individual on why they're gathering that data and why they need that data. Because, you know, maybe you know, your target audience are people who want to go to local concerts, and you want to ask them where they live, and you want to ask them their musical preferences. In this case, it's okay to ask them about who their favorite rock star is. It's relevant, and then they can drive them to the proper music venues with this information. But that's why marketing folks are great at this. They can put it in words, whereas, you know, the folks in the back end who are just coming up with the cool ways of extracting information and feeding it, they might not know what the data is that they're gathering, and it can't tell you necessarily why this is of value to the individual. They were just given functional requirements to get, you know, this data and put it over here. You know, so that's the job of the front of the house folks, the business side, the people who understand why we're asking for this in the first place. And they should be able to articulate it. And if you cannot articulate why you need it and why it could be potentially beneficial to the individual, then you can go back and ask, is it really necessary? And if it's not necessary, get rid of it, or don't bother gathering it in the first place, because then you have to protect it. So let's talk about the right to be forgotten. What is the right to be forgotten? Well, an individual can request the deletion of their data. The following scenarios describe where this request would be appropriate. The original purpose for collecting the data is no longer valid, no longer like ice cream. When the individual withdraws consent, when they say, I don't want you having my data any longer, they don't have to give you a reason. They just don't want you to have that data, and they have the right to request that you remove their data. When the individual objects to the processing and there is no overriding legitimate interest for continuing the processing, you just don't have a good excuse for using it. When the data was unlawfully processed, i.e. otherwise in breach of GDPR. So if you gathered that data and you did not get the informed consent, well, they can say, get rid of that data. The personal data has to be erased in order to comply with a legal obligation. So that could take many forms, but if they are legally required to remove that data, then you have to remove it. So the other right that data subjects have is the right to data portability. Individuals can obtain or reuse personal data for their own purposes. So this allows an individual to move, copy, or transfer personal data easily from one environment to another without hindrance to usability. So perhaps you have credit card and credit reports, mobile phone companies that, you want to take your phone information, you want to go with a different phone provider, well, switch it over to them, give them my phone number and any other relevant data. because I want to switch over to them. So when does it apply? It applies to the processing of data with the individual's consent, and the processing of data specifically for the performance of a contract, such as a mobile phone company. So now let's talk about the future state of how you want things to be with GDPR, a mature organization in terms of GDPR practices. What would that look like? Well, you've created a data subject portal where you can obtain data subject consent. That's where you say, okay, hey, we want your data. Can we have it? That is just one method. You could so that's one thing. You would have a means to inform the data subject of the current use of their data. So that at that portal, so they can see where that data is, what it's being used for, and enable them to request data deletion and transfer or delivery of that data. Maybe they just want a download of all the data that you have of theirs. So that's what a data subject portal, that's really what you want to have. I'll just go back to those things. You want to use a mechanism to gather their consent and inform them of what their data is being used for, and give them the chance to exercise their rights of return or deletion. So what about our current state? That's the thing. We're talking about getting a program off the ground. So here's a pretty good image to really get the sense of what people feel like about this whole exercise. Well, one of the first things you need to do is you need to conduct a data discovery exercise. That's where you're going to want to put together a RACI matrix. Start with what you know. Have the business identify the various processes where they collect personal data. Each form of processing must be justified. We've already discussed much of that, so I'm going to move along. And you want to identify all nodes where this data may reside. It can reside in many locations on websites, in file shares, on people's desktops. So you need to be able to point out where all this data might reside. So one of those places where that data may reside is your supply chain. And so this is where we're going to be talking about the importance of managing your supply chain. So the responsibility of a data controller is to manage suppliers that are data processors. The data controller is the person who is first entrusted with that data and by the data subject, and the data processors are those who do some manipulation of that data. Sometimes the data controller and the data processor are the same things. Other times you farm that work out to specialists. And here's what GDPR says. The controller shall use only processors providing sufficient guarantees to implement appropriate technical and organizational measures in such a manner that processing will meet the requirements of this regulation and ensure the protection of the rights of the data subjects. That's GDPR Article 28 if you're keeping score at home. So identifying risks in the supply chain, you should go through an internal triage process. One of the first challenges is to identify business owners of third-party services who process GDPR scope data in your organization's behalf. Talk to people. Start with your accounts payable. What are we paying for? Are there third-party services out there? Who owns those services? And then talk to those people who own those services and say, hey, are we gathering personal data? If so, let's start the conversation on what is being gathered and handing off to this third party. Develop a standard triage questionnaire to send business owners and to determine if the suppliers are in scope for GDPR. I just discussed that, and assess the risk of the supplier. You're gonna want to poke under the hood and see what these folks are up to, what their practices are like, and you got to manage those suppliers who are processing data on your behalf. You need to make clear what's at stake. So notify them of their responsibilities with respect to adhering to principles of GDPR, emphasizing such matters as legally obtained must be legally obtained data. Data subject rights can be addressed. The data controller might have gotten the consent, but at the same point, the supplier, the processors need to be able to fulfill the request if the data subject says, hey, I want my data deleted. So it's on the controller to ensure that their suppliers are capable of meeting these requirements of right to be forgotten, data portability, as well as 72-hour breach notification. They need to detail in written contracts how processors are to handle personal data. They need to implement methodology of assessing security practices of a supplier. So you need to have a means of just reviewing their practices. And you should consider an automated solution or service provider to manage this for you if you have many suppliers, because if you have many suppliers, sending them a questionnaire and a spreadsheet via email and hoping that they respond in a timely manner and in a sufficiently detailed manner, and you're fighting, it's a fool's errand. You're not going to succeed doing that with a large quantity of suppliers. You need to get an automated solution that's agile and easy to manage. And if it's over your head, beyond the capabilities of your team, get an outside provider that specializes in that. Doesn't have to be us. Data protection by design. This is another key element. You want to show that you've got things going on in your environment to protect the data of individuals. So what is data protection by design, also known as security by design? It's the protection of the rights and freedoms of natural persons, these are the individuals we're talking about, with regard to the processing of personal data. We require that appropriate technical and organizational measures be taken to ensure that the requirements of this regulation, GDPR, are met. So how do you demonstrate compliance with this regulation? Starts with strong policies and procedures, going back to that, and having programs such as security awareness campaigns, training programs, and secure coding practices for your developers. If you have in-house developers, make sure that they have good practices, not just in making neat things happen, but in making sure that their code is free of vulnerabilities and backdoors that let bad guys in. You want to have regular utilization of protective measures, such as minimizing the processing of personal data. Only process the bare minimum. Don't overdo it. Don't be trying to crunch numbers more than what you've said you would do in your disclosure to the data subjects. You want to pseudonymize personal data as soon as possible. Not an easy word to say, but basically use a pseudonym for those individuals. Use a code that can't be traced back to those individuals if you want to do things this way, especially if you're using something like personal health information. Make it so that if that data is breached, there's no way to trace it back to the particular individual. That's what that is. It's a really tough word to say, but it's easy to explain. In short, have a strong security posture. And here we go with talking about the data protection officer. Now, one of the questions, does our organization need a DPO, a data protection officer? Let's talk about the role of the data protection officer. DPO should be appointed if you carry out large-scale systematic monitoring of individuals. GDPR fails to define what constitutes large scale, so you're just going to have to use your own best judgment. But if you think that this is, you look at your business and take an honest approach to that, and you'll know the right answer. If your organization carries out large-scale processing of special categories of data or data relating to criminal convictions or offenses, so that sort of stuff, or if you're doing the making decisions about whether or not somebody gets into your college or gets a loan. or if there's a desire to reduce the likelihood of a breach. So if you're just one of those organizations that wants to do the right thing and you want to make sure the proper protections are in place, get yourself a qualified data protection officer. So what the DPO does, and I'll give you a moment to look at that that cartoon there on the right. I think that gives you enough time. Requirements under Article 13 of what the DPO does. What the DPO is required to do is inform the organization and its employees about their GDPR compliance obligations. They say, hey, this is what you guys have to do and this is how it has to get done. Well, not so much on the how, but the things that need to get done and to demonstrate that you're protecting data. They're going to leave it to the specialists to do things in an efficient manner, but while achieving control objectives. They need to monitor compliance with GDPR. They advise on data protection impact assessments. They say, okay, let's look at these things. What data are we gathering? And hey, let's look at those controls. Are they adequate? They oversee the training of staff, those awareness programs. They oversee internal audits. They serve as the first point of contact for supervisory authorities and for individuals whose data is processed, employees and customers, etc. So, under Article 38, the data controller and processor are required to support the DPO in all matters of personal data. DPO cannot be dismissed for performing his tasks and will report to the highest level of data controller processor. Data subjects must be able to contact the DPO about the processing of personal data. The DPO will be bound by secrecy, confidentiality constraints as placed by a member of the state by member state law. So anyway, going back, that point 2, the DPO cannot be dismissed for performing his tasks. So that's nice little job security. That's a nice perk for a job that in many respects isn't so much fun. There's a lot on his head, but hey, that's the one perk that's worth it. And the DPO can do other things, but they should not conflict with other interests in the business. So you can have a role in the business that's not just the DPO, but if you are the DPO and you're performing the task as the DPO, you know, as well, if you have the bandwidth. So who can be a DPO? The DPO should be designated based on their expert knowledge of data protection laws and practices. What if we don't have somebody with such qualifications? Doesn't have to be in-house. Get a consultancy to set up the practice. That being said, this is more like a temporary solution. You need to be able to manage this in-house over time. So get that person in-house to set up the program and to be there while you're getting the program off the ground, but plan in the long term to have an in-house person trained up to get to that level of expertise, because you're going to want that. And so here's my wrap up and takeaways. Get leadership sponsorship. You will not succeed if the leadership doesn't have your back and isn't pushing people, because nobody wants to do this voluntarily. Rope people in using a RACI matrix. Align policies to GDPR requirements. Implement processes to meet policy objectives and GDPR requirements. Gather evidence and document everything that you do. Take that evidence, because if you do get breached, you want to show that you have processes in place, that you've taken this regulation seriously, and you're doing the best things, and something went wrong, but you know you've done your best, because that will reduce. That can reduce significantly your penalties if they decide to penalize you at all, because sometimes things just happen. And don't forget about your suppliers. You need to make sure that they're doing what they need to do. And automate wherever possible. You know, get the processes right first, but then automate. And folks, thank you so much. That is the end of this presentation, and I hope you enjoyed it. I'm sorry if I went a little bit over.